Hello, my name is Lynette Acosta, and I'm currently a student in the Healthcare MBA program at FIU, taking BUL 6810 Legal Environment of Business. I will be discussing my research paper on the Supreme Court case of Bowman versus Monsanto that took place in 2013. So let's get started. To begin, we will discuss the impacts on innovation in the agricultural industry. It is because of innovation that patents have had to be created to regulate and maintain the relationships in our society. In this case, patents state that an entity, whether individual or company, has a designation on an invention and therefore has a sole right to exclude others from producing, using, or selling of an invention. In terms in the agriculture industry, which is what we'll talk about today, and the base to the case, patents in agriculture states that patenting a plant trait, the owner has the right to restrict farmers purchasing the products from sowing, planting, harvesting, or breeding the variety of a plant without permission. Meaning, in this case of Mr. Bowman with Monsanto, he will not be able to use the seeds again. All right, so moving on to the next slide, we're going to review just a little bit of Monsanto so we understand the groundwork. So they were founded in 1901. They're very well known and established. They're both local here in the United States as well as international. It's known as an agrochemical and agricultural biotechnology corporation that is primarily known to be a mass producer of pesticides and genetically modified crops. Interesting. So if we look over to our next section, it's patents. So they received their patents in 1994. They were granted a patent for genetic material from a virus that can be used to incorporate new genetic material into a plant. And in 2006, they patented a gene that makes plants resistant to the glyphosate-based herbicides that farmers use on weeds. Meaning these new seeds that they were generating or creating, known as Roundup Ready seeds, would have a repel. They would repel the pesticides that would be used. So it would kill the weeds, but it wouldn't kill the seeds. So looking now into Bowman versus Monsanto in 2006, they presented a suit against a farmer in Knox County in Indiana by the name of Vernon Hugh Bowman. And this suit was for infringement. So what happened with Bowman was that he bought seeds from a third party. And this third party is known as a grain elevator. He then took these seeds, planted them, and as they grew, they created a new generation of seeds. He then took those seeds and he put them away for future planting, and he planted a few. So Mr. Bowman had done business in the past with Monsanto, so he knew the rules and regulations of the planting of the seeds. However, after the first use, Monsanto started investigating. And so what gets a little gray for Mr. Bowman is that he didn't purchase them directly from Monsanto. He bought them from the grain elevator. So that's where it starts getting a little gray. So Monsanto began to investigate, and that's how they determined that they would file a suit against Mr. Bowman for the misuse of their product. So moving into our next slide, we're going to talk about the first court cases. The first one was the United States Direct Court in the Southern District of Indiana. So this was the first one. His argument to their allegations was that he bought the seeds from a grain elevator, just as I stated previously, and those had already been patented following a certain set of regulations. So when he planted them, he didn't think it would cause any adverse issues with Monsanto. However, in 2009, after they finished the case, they determined that the permission of the original creator still has to be obtained because regardless of the location of purchase, those seeds belong to Monsanto and they're regulated strictly with their rules and regulations. So as we move forward, he files an appeal to the United States Courts of Appeals for the Federal Circuit And in this case, he is explaining that Monsanto allowed for the sale of the seeds to the grain elevator, so therefore they're forfeiting their patent rights on those seeds, and so it didn't apply to him. The argument did not hold. Monsanto was ruled in favor, and they awarded Monsanto $84,456 in damages. So moving forward, Mr. Bowman then filed the request for a Supreme Court hearing. So now we're moving forward into his hearing that took place in 2013 with the Supreme Court. He presented a case, the United States versus Univis Lens, which states that patent exhaustion limits the patentee's rights to control what others can do with an article, whether it embodies or contains the invention. So basically that Monsanto didn't have the right to regulate those seeds because they had gone through a third party. So Monsanto argued that the previous court hearings at the federal level were correct because the creation of the new product was still using the original strain. So in May of 2013, the verdict was issued in favor of Monsanto. It was stated that he indeed could have sold or used the seeds as feed for his animals, but since he used it to create a new seed altogether, it was in violation of the 35 U.S. Code 271 of infringement of patent. So Mr. Bowman could not have created additional patent beans from the original seed without the permission of Monsanto. The reasoning for this is because the patent protects the genetic makeup of the bean, so of the seed. So he would only be replanting the same genetic seed and just creating different strains of it, but still repellent of any pesticides or any chemicals that they would use to take care of their crops. So still, at the end, would be a product of Monsanto. So looking into our discussion and analysis, farming has changed substantially. The farming habits of the past are not the ones we have today. And farming was a lot more organic, and people were able to hand down land from generation to generation because it was so rich. It was so rich and pure. So in today's world, the demand has moved quickly, and the urgency to have less error, to have less loss of crops is key to survival in agriculture. So people are seeking out chemical advancements, genetic advancements, ways to create crops faster, ways to keep them from going bad, from lasting longer. So the implementations of these patents have come now closer towards the 21st century because the advancements have changed so much. So Mr. Bowman, being a senior citizen and doing this for multiple years, is actually introduced to this newly as time has changed. So it has become a real problem nowadays compared to the past. This just goes to show how law is ever changing. It adapts to the innovation that's going on in our society. It brings the demand of regulation to keep things in order. And so the agriculture industry is not any different. This case goes to show that the changes in our environment and our social and economic demand are now pressing for these type of court hearings. Mr. Bowman is such an older gentleman, as I stated before, trying to adapt his older farming habits to this ever-changing environment. So what may have seemed an innocent slip of misjudgment can now be a legal matter that can be taken as far as the Supreme Court, simply because technology and advancements are changing. And that's just, that's just where we're going now in the future. So that concludes my presentation. Mr. Bowman, I think that for him it was a learning experience in a new era of farming, of changes. And so the takeaway from this case was that, yes, we have to adapt. We have to adapt to the different things that are happening. That, yes, if we choose to use a supplier who has patented products that we need to respect it and move forward with it. Okay, so thank you so much for joining me in the Supreme Court case of Bowman versus Monsanto. And here are references. Thank you, and have a great rest of our cohort. Take care.